Welcome everyone. Thank you for joining Decolonising Land this afternoon or morning, wherever you are. The event will begin shortly. We're just going to wait for a few participants to join and we'll start in a couple of seconds.
Hi, everyone. My name is Sfiso Benard Nxumalo, and it is my privilege to welcome you all to this event, Decolonising Land. This event was organized by the Oxford Law Black Alumni Network, of which I am the president, in conjunction with the Oxford Faculty of Law. October is Black History Month in the UK, and we thought it would be apposite to discuss property during this important month, particularly due to the colonial life of property and how it continues to be a device used to perpetuate inequality and the exclusion of the marginalized. It is tried that property in its various forms was central to the colonial project. Colonialists even went as far as claiming to create a colonial fiction known as terra nullius, which originally meant that the land was unowned or unoccupied. I say that this was a colonial fiction because terra nullius was then expanded to apply to certain lands that were in fact occupied by indigenous people, provided that the land was uncultivated or not put to productive use. The meaning of cultivated and productive use were, unsurprisingly, racist and sexist. Today, we hope to unpack some of these key issues and discuss the decolonization of land and property more broadly and land reform. I am absolutely honored to introduce the brilliant speakers for today, who I personally think do not need any introduction, but one has to adhere to the formalities of these kinds of events. Our first speaker is Elmien du Plessis. She is an associate professor in the Faculty of Law at the Northwest University in South Africa. She holds a BA in International Relations, a LLB and LLD from the University of Stellenbosch. She obtained her doctorate on compensation for expropriation under Constitution in 2009. She is interested in property issues, especially in land reform, in the land reform sphere. And she has published numerous articles and chapters in this area. She is interested in the stories that the law tells, but also in investigating whose story gets told and why. Our second speaker is Advocate Tembeka Ngcukaitobi SC, who is a preeminent silk in South Africa. He holds the degrees of a BProc, LLB, LLM, and another LLM from the London School of Economics. He is a best-selling author of the book, The Land is Ours, and also Land Matters. He was an acting judge at the Land Claims Court. So we are very lucky to have his insight and expertise as a practitioner and an academic. On the structure of this event, the speakers will have 20 minutes each to discuss the topic, and then we will have a Q&A at the end. The Q&A function is at the foot of your screen. Please feel free to ask us any questions at any moment, but please do take into account the fact that this event is recorded, and if you ask a question, your name will be mentioned unless you submit a question anonymously, and your name will therefore not be mentioned. With that being said, it is again my great privilege to introduce our speakers, and thank you both for joining us, and over to you, Elmien.
Right, thank you for the introduction. So let me just start here. Okay, so I want to thank you, Sfiso, for reaching out for the invitation to speak here today and to speak alongside my colleague Tembeka. Decolonial theory is a big terrain, so I acknowledge from the outset that I will probably leave out much more than I include in these 20 minutes. So I see this as a start of a conversation and not an end. In preparation for this talk, I returned to the writings of my colleague, most notably Professors Modiri and Madlingozi. It made me wonder whether the work that I do can indeed be classified as decolonial, and indeed what decolonization of land means. I think that part of my work, I do think that part of my work can be classified as decolonial, although I also accept that we carry various ideologies or viewpoints and identities with us in us that's often contradictory. So I think that is an important conversation that we should all have about what decoloniality means. So to set a framework for my talk, I will start by setting out my at the moment position on decolonization and decoloniality, before I will discuss the implication of this, or what I think the implications of this is for property law and our understanding specifically of compensation for expropriation. Of course, I welcome a broader engagement on land reform issues in the question and answer sessions, but I had to choose a few points to focus on. So there's a fringe argument that I found that colonialism ended in 1960 in South Africa, that the Afrikaners were also colonized and that the Dutch never colonized South Africa because it was the VOC and not the state that set up the refreshment settlement here. So I perhaps oversimplified that argument for now, but these arguments often arise in conversations that seek to negate Afrikaners' moral responsibility in reparations or ensuring equitable redistribution of land, or where there's a strive for a new nationalistic identity. I don't ascribe to this view, although I can leave room for a conversation about Afrikaners' subjugation to British rules, and then in order to understand rather than to negate certain responsibilities that we have. But a more serious engagement with decolonization comes from, in South Africa at least, comes from Professor Madlingozi. He proposes the start of a process of replacing the entire current constitution with a post-conquest constitution. For Madlingozi, the constitution is part of the counter-decolonization project of masking white hegemony and historical conquest through the economy of recognition, incorporation, distribution. So there's a whole theory around that. But he relies in this aspect on the argument of Ramose that says that an authentic constitution in South Africa will terminate a putative right of conquest. This right of conquest, this putative right of conquest, Ramose says, is constitutionalized and therefore solidifies the unjust wars of colonization. Such a new constitution is also one that is permeated by the spirit of restitutive justice and reparative justice to enable restitution and compensation for the damage done in the application of the right to conquest. So in this regard, then Madlingozi argues that a decolonizing constitution is bifocal in the sense that it is both backwards looking and forwards looking. So it seeks to break from the past and it lays down a post-segregationist and all-inclusive future to attain a sense of effective and material belongingness. Ramose, I should say, argues that the South African constitution, the negotiations that we saw in the early 90s, rest on contending paradigms, democratization and decolonization. So where decolonization seeks to nullify white conquest of land by restoring territory and sovereignty, which is what he focused on, to the indigenous majority, democratization extends rights to conquerors, he says, and conquered, but reflects the conqueror's view that injustices that occurred a long time ago should not be rectified. And this is decolonial, he argues, because an injustice remains until it is rectified. In this sense, negotiations became a second conquest by consent and not by force. So for Ramose, decolonization calls for a return of all land, placing it under traditional authority as before colonization, without subjecting any of these traditional authorities under the constitution. So my position does not fit in comfortably with this view either, though I can agree on certain statements or viewpoints that's offered here. For one, I share the same concerns that the Constitution has not adequately addressed the problem of inequality and poverty in South Africa. I also agree that we have seen limited restoration, specifically in land reform. I perhaps differ from them because I do not lay the blame solely on the Constitution. At times, I actually find the reading a very restrained reading of the Constitution, giving it an unavoidable and unchangeable meaning. Things will happen, and we, the people, are powerless in stopping or changing the course of what will happen. I also agree that since the control over land was central to the colonial project, as you've mentioned, Sfiso, the land will have to play a central role in decolonization. The law had a central role in all of this, of course, with the imposition of foreign land tenure systems aimed to protect the interests of the European settlers with little regard to the local African people. So my interest lies in how do we address this? How do we repair and in the process of reparation, ensure that we rehumanize people? Can the law actually do that? And can this happen within the current legal framework? Does decolonization, as Ramose argues, only happen if the Constitution in its entirety is abolished, land returned under governance of traditional authorities? Is that the only way? I don't think so. I'm not saying that the past is the past and we must move on. If we want to escape the cycle of violence over land in this country that we've seen for centuries, we need to do things differently from what we have done the past 3.5 centuries. This is why I have to prefer the term that Ramose also refers to, reparative justice over restorative justice in this context. We are not trying to restore because certain things cannot be restored, but we are trying to repair. In this context, decolonization is not simply about reversing what colonization did. In many ways, this imposes a static view on African societies. Instead, a decolonial project wants to understand and expose distortions. It highlights the violence of privileging common law, for instance, or statutory tenure over customary tenure, and identifies power imbalances. This process then aims to find ways of reorientating the thinking, aspiration, perspectives, knowledges, and the being of the colonized. As was stated by various scholars, it requires us to move away from the widespread and stubborn misrepresentation of Africa as the African cultures as static, bounded, and primitive, rejecting placing colonial epistemologies over endogenic systems of knowledge. So in this regard, I think if I have to take in a position, my position is similar to that of Zitzke, who states that decolonial legal theory in South Africa, broadly understood, involves a critical engagement with the persistent effects of European colonization on the lives of African people through the mechanisms of law being a creator and a maintainer of coloniality, and in the view of some, a strategic weapon of resistance against coloniality. If it can be accepted that some of the cardinal sins of European colonization in Africa have been land dispossession, political disempowerment, economic disenfranchisement, psychic violence, and epistemicide, then the lasting effects of these colonial instances of violence through law is what is exposed and addressed by South African decolonial jurisprudence. The core concern, according to him then, is resisting the persistence of coloniality, not simply recalling colonialization as some vestige in the very distant past. So perhaps my uneasiness with a decolonial approach that calls for a wholesale abolishment of the Constitution in its entirety stems from my warts and all acceptance of the Constitution. I accept that the Constitution is not perfect, but I also acknowledge that the Constitution is not complete and that it carries within it contradictions and tensions that are constantly interacting and creating. So since constitutions are provisional and meaning open to contestation, it makes room for expressing African notions of justice. What then is needed for change? For scholars like Friedman, the solution lies in collective action to turn constitutional values into reality. Friedman states that blaming the Constitution becomes a substitute for showing how a society which perpetuates the past can break free of it. In that sense, the Constitution is then always an unfinished and open-ended affair, and it never settles conflicts permanently. A constitutional framework then allows for a space to disagree without violence, but it does not necessarily state what change is desired or needed. That is left to us, the people. So Chamberlain wrote very beautifully on this topic when he stated that constitutions are stories we believe in. They embody all the contradictions of a story. Sometimes our belief in a creed of a constitution is simply hope, but it is an inspiring hope. In this respect, our constitution is full of promises. We recognize the injustices of the past, or do we? We honor those who suffered for justice and freedom in our land. Who are they? We respect those who have worked to build and develop our country, and sometimes we also believe that South Africa belongs to all who live in it, united in our diversity. We might want to believe it, but whether it is actually true is another question. It is perhaps then no coincidence, knowing how much is needed for this to happen, for this belief to be true, that the preamble ends with Nkosi Sikelel' Africa, God help us. What then are the implications of all this for property law? So a pre-constitutional system of property law elevated titled private property to the top of a hierarchy of tenure security, which invariably favored white people as owners of the largest portions of land and ensured that all other property rights were always dependent on the mercy of these owners. Other rights in property never stood a chance against this all-powerful white owner. The Western notion of private ownership then prevailed. It was recorded in legislation and in administrative systems, and where there was a void, of course, comfort was taken in a specific interpretation of the common law, a law with European roots. Today, we sit with two diverse property regimes, a system of individualized common law, Roman Dutch, land ownership, predominantly based on civil law principles, and a system of so-called communal tenure, where we refer to land held in terms of customary law. On top of this, various other land rights exist alongside these rights in land pertaining to tenure. Official information and protection of these rights are lacking with regarding to land, especially held in terms of customary law and other sort of tenure rights. 20 years ago, Van der Walt warned that a successful land reform program need to move away from this emphasis on ownership and should seek to dismantle this hierarchy of rights and so identify and protect more rights and property. I would add here, and to identify and protect them in a way that makes sense to the people who will exercise these rights. See, there are 100 words for snow in Russian. Snow, falling snow on the ground, snow used to make water. Snow is essential, and you need to be able to distinguish between snow when you can walk over and snow that you will sink through in Russia. And if language then indeed shapes our word, not having certain words lead to a deprived experience. Property not being a natural right, but a system that is politically determined, means that it involves choices of what rights we are going to see or name or recognize and protect and what not. If about 30 million people in South Africa live off register, in other words, in a system where the law does not have words for their property rights, it leaves them invisible. But they are there. The decolonial project for me then demands addressing the violence shown to other forms of knowing and being by naming these rights and protecting them. So this is a snapshot of what is a relatively radical transformation of the property rights system. But what then about the other issue of reparations? So Ramosi states that the Constitution ignores the African view that an injustice remains unjust unless and until it is rectified. Can the law do this? Mandami argues that Africa should regard past violence and injustices as a political rather than a criminal problem, requiring a constitutional foundation to forge a post-apartheid political order. In that sense, the Constitution did not bring about the new order, but created a space for creating one. Likewise, scholars like Wilson also see the law as an agent of social change due to its ability to create or destroy spaces in which social groups can think and can act to give effect to their plans and aspirations. In other words, once we have a constitutional document, it does not replace the need for action. In fact, it calls for action. So where does this leave us all with regards to Section 25 of the Constitution? If it is the belief that South Africa belongs to all who live in it, and if this is our only way out, this implies that if we cannot find a way to all live in it, that might be the downfall of the South African story. If the Constitution is a story filled with promises, one way of framing the Section 25 conversation then is interrogating the very ideas on what being a country entails. The choice of a constitutional democracy with the supremacy of the Constitution that contains a Bill of Rights means that we chose an approach based on human rights. This approach did not necessarily want to punish the original dispossession, and it does not assume that expropriators will be expropriated. But this human rights approach does require that the consequences of years of dispossession under specifically apartheid be considered when a system of property rights are constructed for the future. It's not only thinking that originated during the negotiations. In fact, when I read the testimony in the trial of Biko during his South African Students' Organization trial, at one stage, the prosecutor asked Biko to explain his stance on expropriation. The prosecutor asked, "Is there any part of your program which suggests that all private property must be expropriated, full stop?" "I'm not aware of this," was Biko's reply. During interrogation, the court intervened. "I think your counsel is probably afraid to mention it. Isn't it part of the policy to have a redistribution of wealth?" "That is correct," Biko answered. The court was confused. Now, how can you have a distribution of wealth without taking it from somebody? So Biko had to explain that it is possible to take from somebody without abolishing the principle of private ownership. Explaining property, he answered, "My relationship with property is not so highly individualistic that it seeks to destroy others. I use it to build others." The court seemed to have accepted this, but was still very uneasy. So what about the white man's property? Biko answered that it is possible that certain people in the country, according to whichever values are adopted at the time, own things that they should not have, which historically they have immorally got to a point which cannot be forgiven. Continuing on this, Biko foresaw the possibility that a time might come that people might be told to give it back. "We will give you what we think it's worth, you know. It will be the government that pay this price, what the government thinks it's worth." So in a sense, Biko foresaw some form of compensation, even if not full market value. And thus, years later, Section 25 of our Constitution shifted our compensation standard from market value to just an equitable compensation. So Section 25 is arguably a chance, of a process, a chance conclusion of a process in which it became clear that addressing the matter of redress of land cannot happen without compensation, but that sometimes justice will require that compensation cannot be market value. I think that was not taken into account. What was not taken into account was the possibility that the non-implementation of these powers by the state, alongside a legal culture that allows for only small incremental shifts on its view of property and compensation, will happen in a society where the needed redress did not happen spontaneously. So rights talk, such as debating the amendment of Section 25 or abolishing the Constitution in its entirety, does not happen in a vacuum. This conversation is also about reparations, with the underlying conversation always being the question, who must pay for addressing the injustice of the past? But as a written text, the Constitution requires interpretation to be understood, and even more so for concretization, that's applying it in concrete situations, to manifest its application. So while a written constitution is final because it's fairly cumbersome to amend its wording, as we've seen, it is also very open because of the inclusive but inconclusive wording. The fact that a constitution is written in words means that the text serves as an essential starting point for interpretation and applying legal rules to a concrete situation. However, the inconclusiveness also allows for improvisation as society changes. The elasticity of the language of the Constitution provides for evolution, growth. It leaves a wide margin for conceptual decolonization in that sense, for a conversion of various stories. So during Biko's trial, the court at some stage asked Biko if he foresees going back to the 6th century. After explaining that the prevailing culture seems European, he states that we do not want to be just mere political Africans. We want to be people living in Africa. We want to be called complete Africans, social Africans. Sure, it will have European experience because we have whites here who are descendant from Europe. But for God's sake, it must have an African experience as well. So maybe, just maybe, with the help of the hopeful promises in the preamble of our Constitution, holding our often contradictory stories, all this might just be possible. Thank you.
Thank you for that, Prof. I must confess that I find myself more and more agreeing with the Joel Madiris of this world. And I think from the top of my head, when I think about property, I think that the current injustices that exist under private property cannot be accommodated within the current property sort of doctrine, that there has to be a complete rethink of property law as we know it. There has to be a reimagination and a reformulation of the language and the rhetoric of private property. I think that what we've seen over the years and with the Constitution itself is that what it's done is that it's tried to accommodate injustices and sort of create exceptions to private property rather than actually fundamentally reshaping private property and centering the marginalized. But that is a conversation I hope we will continue afterwards. I wish to sort of implore people to please send in your particular questions and let's have a conversation about this. Now over to the Honorable Advocate Tembeka Ngcukaitobi.
Thank you very much, Sfiso. And just to express my gratitude to your organization and obviously to my colleague Elmien that I have been in the trenches with, actually on the same side for the most part. I want to start by telling a story, of course. In April 1819, Mr Tembeka of the Khakhabe section of the Xhosas declared war on the British in Grahamstown. He had 6,000 men armed with spears, shields, sticks. There were only a few hundred British soldiers, but they had cannons, rifles, 6-pounder guns. The British, of course, were not alone. Alongside the British were the Boer commandos and the hundreds of the Khoi. Ndlambe's men were no match for the artillery of the British. When that war ended, a mere 4 weeks later, Ndlambe's men had been annihilated. Ngcele's medicine could not withstand the guns of the British. At the forefront of the onslaught against the Xhosas were the Khoi. The Boer commandos followed. They laid waste to hundreds of Mtushane's men. Then the British troops entered. They perfected the killing frenzy. In the book, A Proper Degree of Terror, Ben McClellan describes the scene of war. As the warriors came within range, the artillerymen opened up a devastating fusillade, mowing down whole ranks at a time. The warriors let loose the first volley of spears, which for the most part fell short and were ineffective. Then, with their chiefs cheering them on, they advanced almost to the muzzles, the mouth of the British guns, and many, within a short space of time, took their last breaths. They surrendered. They were shouting and praying, "Die, die." asking for forgiveness, but also asking for redemption. As that war ended, in bitter defeat of the Xhosas, more was to come. Makhanda Kancele was taken prisoner and sent to Robben Island. But there was more land taken. Political control was exerted. The Cape Town Gazette, essentially a mouthpiece of the colonists, reported that there were only 500 Ks, using the K word, that were killed. But later estimates showed that there were thousands killed, excluding the injured. The Xhosa Spears and the Prophecy of Nxele killed no more than 5 people. The war broke the spirit of resistance among the Xhosas, but the British wanted more. 30,000 cattle were confiscated. Cornfields were burnt. It was scorched earth. They expelled people from their homes. Thomas Wilshire, a colonial administrator stationed in Grahamstown, found some delight in the macabre practice of K-word hunting, in which Xhosas were hunted and shot on sight. Awards were given to those who brought human skulls of the Xhosas. The plundering of the land, the political subjugation of the Xhosa, and the confiscation of their cattle as spoils of war were familiar to the people of the Eastern Frontier. This was, of course, what the British had done for 200 years. Although today the memory of conquest occupies a precarious position, sometimes at risk of being erased by distortion, by contestation, and sometimes by sheer exasperation, the fact remains that the urgent task of decoloniality is the restoration of memory. Colonialism was a totalizing system. It exploited African labor for the benefit of the white economy. It expropriated the land of the Africans for the benefit of the white economy. It produced intolerable living conditions. It destroyed the physical existence of African populations. It created native reserves and ghettos. There were mass and arbitrary killings of Africans. The state was indifferent to disease in Black areas. African livestock were confiscated. Have we ever wondered how it came about that Van Riebeeck, who came to the Cape with no more than 20 men, now represents as a symbol a population of Afrikaners that is known for farming, owning millions of Nguni cattle? Have we ever asked ourselves how they could have acquired them? Following Lauterpacht, by 1973, the international community could rightly condemn apartheid as a crime against humanity. Yet, if Raphael Lemkin had been alive in the 18th and 19th century South Africa, the barbarism of the British of the Cape could have been described as a genocide. For 2 centuries before apartheid formally began, the British had long laid the seeds of racial segregation, property dispossession, and the construction of a racial oligarchy. Together with the taking of property, the British also imposed, and I suggest, the most significant imposition, an external culture coded as civilization. This external culture has undergone changes over time. At once, it was called development, and later it was called nationhood. But its core is civilization. It is in the sphere of the mind, the sphere of ideas, that conquest continues to live. It continues to imagine and reimagine itself, and it continues to restrain and constrain our ability to think differently about the future. Nowhere is this pretense of civilization more prevalent than in the intellectual justification for the dispossession of property. I should start by the reference to the 1846-1847 report of the Natal Locations Commission. Its purpose was to create native locations in order to formalize white settlement. Of course, this was after war. Law always followed war. One of the chief members of that commission was Theophilus Shepstein, who we now know as the prime theorist of Zulu customary law. His report did more than it had announced. Its enduring outcome was to subordinate the African systems of land ownership to European modalities. This is how the report explains the position. The natives' own laws are superseded. The restraints which they furnished are removed. The government of their chiefs is at an end. The Commission's proposed system allowed colonial officials to recognize, de-recognize usages of customs of native law. Thus, natives could use their own system of land ownership, provided it was subordinate to European laws. This would be cemented by the Native Administration Act of 1875, which absorbed Africans under the former colonial justice system. By the Code of Zulu Law of 1878, purporting to be about law, but in reality about land and a lasting legacy. This code would relegate the status of African chiefs. Each chief would be a minor deputy to the Supreme Chief. The Supreme Chief was the colonial administrator. He could hire, fire, dismiss. The role of chiefs was essentially to carry out the instructions of the colonial masters. The prime concern was the labor and the defense needs of the colony. Not only could he hire and fire chiefs, he could create kingdoms, chiefdoms. He could destroy existing ones. He could combine others. He could remove people from the land. In fact, land could only be allocated by a system of government-appointed chiefs. No exception could be made for the family. Women were placed under the control of men as perpetual minors. This is the law, as it stated. The family head is the owner of all family property in his home. He has charge, custody, control of the property attaching to the houses of his several wives, and may, in his discretion, use the same for his personal wants and necessities, or for general family purposes, or for the entertainment of visitors. By virtue of Section 22 of the Code, the inmates, including women, children, irrespective of sex or age, are under the control and owe obedience to the family head. The family head himself owed obedience to the chief. The chief owed obedience to the Supreme Chief, who in turn was the colonial administrator. This code was reflected as containing Zulu custom, yet it was a distortion of custom. Take one example. Before 1891, when the code became operative, women could work independently of their husbands. They could conclude contracts. Girls could marry people of their choice. As far as property was concerned, it was a fallacy that women had no property in Zulu society. A father could give property to their daughter, and that became her property. There were instances where a husband could bequeath cattle or other property to his wife. Zulu King Echwayo Kampande gave evidence at the Commission of 1883 that women, married or not, could acquire and hold property independently of their husbands. In fact, the changes to the law that came from the Shepstein system altered emerging economic phenomenon of the 1880s and 1890s of independence among women who had taken up employment as migrant laborers in the new white settler economy. With this changing economic climate, women asserted their independence, challenged the authority of men, and times resisted domesticity. This new law, establishing kroll heads, granting authority over property, giving the rights to inflict corporal punishment, simply constrained any possibility of independent economic and social activity by women. In summary, chiefly power consolidated in the code drastically reduced the possibility of independent, liberative economic activity of women. But it also destroyed the ability of communities to control the land according to their own laws. It placed them firmly under the discretion of colonial magistrates. These changes by Shepstein have come to be accepted as Zulu customary law. The Natal Code of Zulu law was no longer seen as an externally imposed system of law, but as reflective of Zulu customary law itself. The last half of the 19th century can rightly be regarded as having laid the seeds of this colonial distortion. A central attribute of this distortion was aligning chiefly control over the land. This much is clear from a Native Administration Act, not of 1857, but of 1927, which now applied to the new country established in 1910, called the Union of South Africa. For the first time, the four colonies, the two colonies of the British and the two Boer republics were combined into one country. But it was a white man's country. The blacks, the native people, were spectators. That Native Administration Act opened up in the first section that for the better control and management of native affairs, the Governor General shall be the supreme chief of all natives, exercising all such powers as may be vested by custom or by law in a paramount chief, and he may appoint officers under him and administer their affairs. These distortions over the control of land and the disruption of African ways of being extended to the concept of ownership. I want then to move to the next half of my paper. How did this happen? How did the colonial administrators extend control over ownership and justify it? Take the 1875 dispute over the diamond fields of Kimberley. This was not a dispute about diamonds, but a dispute about land. At issue was who owns the land where the diamonds were found. Remember, the whites claimed to have discovered the diamonds. And thereafter, they fought about the spoils of the discovery. There were a number of potential claimants: the Afrikaners, the diamond diggers, the Griqua, an indigenous group. The Griqua argued that the area was theirs because of prior occupation. And they claimed that their rights of prior occupation had not been extinguished. There was a law that applied, which said land occupied bona fide and beneficially without title shall not be considered or treated as crown land until a claim thereto in each case shall have been decided by the government. So unless the colonial government explicitly took customary lands, no presumption could be made that customary title or indigenous title was extinguished. But in the case of the Griqualand West in 1875, the very first land court for the Griqualand West, Andres Stockenstrom, the judge, decided that the Griqua people were nomadic. They had no fixed land or area. They moved from one area to another. And their legal system did not recognize any form of land ownership. And here, the trickery of the British can be exposed. Because the ownership was communal, by the simple act of distorting its nature, Stockenstrom could deny the existence of ownership entirely. This became a repetitive story. Take the report of 1898 by Chief Justice Rayner about West Africa, not about South Africa, in which he says, my experience in Lagos, in Nigeria, leads me to the conclusion that except where land has been brought by the present owner, very few natives have ownership of the land. Another case decided by the Privy Council itself in Re Southern Rhodesia, 1918. We remember this is a notorious story. The backstory to it were concessions over land and minerals purported to have been signed between Cecil John Rhodes and Chief Lobongula of the Ndebeles, the indigenous people of Zimbabwe. The nature of the agreement, in effect, was an X. It was dubious from the onset. Lobengula had been duped by Rhodes into believing that he was signing an agreement for surveying the land. And Rhodes turned around and claimed it was an agreement for the sale under the so-called root concession. Lobengula resisted, relying on the sovereignty of the Ndebele people against the British Crown. When the case came before the Privy Council, this was the manner in which they summarily dismissed Lobengula's claim. Some tribes are so low in the scale of social organization that their usages and conceptions of rights and duties are not to be reconciled with the institutions or the legal ideas of a civilized society. It would be idle to impute to such people some shadow of the rights known to our law and then to transmute it into the substance of transferable rights of property as we know them. The distortion, which continued for the next 100 years, was complete. Customary rules, as perceived by the colonists, were established. Women had no rights to the land. Africans had no conception of ownership. The Zulu Code of Native Law, which emanated from colonial authorities, became the law for the blacks in Natal. Shapstein's vision had come full circle. The foundation for the stripping of land rights of African communities in the name of African customary law was complete. Once the judiciary, the judges, accepted these distortions, they became common sense. The apartheid state embraced these distortions. They were central to the establishment of the Bantustan regime, separate development and dispossession. So the demand of the struggle for freedom was the dismantling of the colonial state, but there was a gap, never the dismantling of the intellectual justification for private property. In fact, leaders of the African National Congress, for years after its establishment, embraced the conception of private property. How did they do so? This idea emanates from 1851, where the Cape government, the British Cape government, linked the rights of franchise with property ownership. And so the struggle for property ownership became to be known and linked to the struggle for liberation. We had to own property in order to vote. We had to vote in order to be free. And so this was never possible during the struggle because the leaders of the struggle themselves were caught up in a combination of admiration and fear of the power of the empire. What choice do we expect these men to have made? What choice should Seme have made between the Boers and the British? The British promised civilization, although they did the opposite. But what choice do we have now? What can we impute of them? Take, for instance, the contents of the 1923 Bill of Rights, drafted by the ANC itself, by one of its most intellectual leaders, Pixnika Izakase, in which he proclaimed that Africans admitted that they were the children of empire. We have embraced these concepts of empire. They continue to live in our imagination. They continue to be constitutive of concepts of liberation. They also continue to define what the future is. The post-democratic state has fared no better. Take, for instance, the Ingonyama Trust, passed only a few days before freedom. It was a continuation of the decades of the colonial imposition of chiefly authority from above. Its key tenets were simply a modern version of the Shapstein modernity, or rather, version of modernity. It stripped land rights of individuals and family. It concentrated power over with chiefs. It diluted customary norms. It distorted them with versions of Western legal modernity. It imposed indirect governmental rule. And prominent among these ideas is trusteeship. It is the idea that native people have no concept of ownership. The land vests in Ingonyama or a colonially appointed chief, and never to the individual, to the family, to the community. And the powers of the trust itself are vast. They administer all land that falls under their jurisdiction. And therefore, it was inevitable that there would later be clashes. Because on the one hand, the framework of the Constitution promises change, but that change is constrained from the beginning. And it opens up avenues for contestation, for conflict. There is, as I point out, an inevitable conflict. And that inevitable conflict, most of us hope, would be taking place in the legal sphere, in the judicial sphere. My colleague today has spoken quite correctly about the need for a reparative project. But that reparative project must take place both in the material and in the metaphysical. It must take place in the classroom as well as in the middle field. It is no longer an answer to tell people that they can rely on rights. What they want land. They don't want it tomorrow, they want it yesterday. They can no longer rely on the promise that the future will be better. They want the present to be better. There are promising signs of the future. One of them is a recent decision by the KwaZulu-Natal High Court, in which for the first time, customary modes of land ownership are inserted, recognized, and entrenched in jurisprudence. There are also signs from the discussion currently taking place about whether or not state custodianship should be embraced instead of the unbridled common law notion of private property, whose telos is exclusion. Of course, African people did not fight so that the land could be owned by the state, but it is promising that there is a debate as to whether private property itself should be part of our conception for the future. But that idea of private property should not negate the necessity for freedom, for restorative, for reparative. A colleague recently asked, who shall we claim reparations for? Did they ask many other societies where the reparations should be claimed from? It is clear where the reparations ought to be claimed from. We have the Dutch, we have the British, we have the Afrikaners, but we have an entire Afrikaner economy built, sustained, and established on the back of Black labor. But we have to think more beyond reparations. We have to rethink our conception of land, our relationship to the land. Recently, I did a case reported as the Tolobeni, known as the Tolobeni case. One of the old men from the village who I met and spoke to for the first time in court told me in Xhosa that this idea of land perplexes him because he always understood that land is to be used, but then it is to be looked after. And the reason for it is so that future generations can also inherit it. Finally, I want to make one final observation about the imagination in the Constitution. I suggest that when South Africa adopted the Constitution, it began the path towards the negation of its colonial and apartheid past. It saw the Constitution as the primary means through which it can contend with its past and it can imagine a new future. But I think that is not possible as long as we continue to be trapped in a legal paradigm of the same society we seek to transform. The Constitution itself wants to make us better. It wants to lead to a new society underpinned by new values. But we must disrupt the past so that the promise of the Constitution is not constrained and it is not scuttled. So if we return then to where we started, to the distortion, how should we think about the future in relation to transformation of property? I think this is, of course, a broad topic. It must at least include the reimagination of the past. There are multiple pasts, and the futures, there are multiple futures. It must recognize the complicity of the law in colonial conquest. And at the same time, it must recognize the potentiality of the law as an instrument of liberation. These two do not need to be irreconcilable premises. They can be points of intersection, sometimes collision, and often points of overlap. No clear lines can be drawn between the past, the present, and the future. But we must remember Wilke Faulkner. And I suggest he is right when he writes in his novel, Requiem for a Nun in 1951, that the past is not dead. In fact, it is not even past. Thank you.
Thank you so much for that, Tembeka. That was very insightful. I'm sure everyone learned quite a lot from the story that you told at the beginning. With that being said, there are some questions in the Q&A that I will read out. And I will indicate. So I'll start off with a question from Sarah. Sarah says, my question to both the speakers. What reparative measures have been made towards the decolonization of land, and have such measures been effective so far? What could you recommend going forward? So Elmien, would you like to take the first jab at that?
Yes, I can start. I think it also depends on, sorry, I'm just reading the question. Let me just put it on this screen so that I can watch you in the eye. You know, we have a whole land reform program that's called the restitution program, but it is limited in its time. So it only restitutes land that was dispossessed after 1913 in terms of a racially discriminatory act, and communities had to lodge their claims by 1998. There was a short period where Amendment Act opened that process again until that amendment bill was declared unconstitutional. And I think Eka will agree, there are so many reports that show that communities have to go, I think they have to go through 144 judicial acts. So there are 144 steps that they need to take before they can be successful with these claims. And in that sense, it's very limited. So I think the idea with the restitution was to provide some sort of, it's also very restorative in that sense that it directly tried to restore land to people who were dispossessed of specific pieces of land. But when you go back to the conversations that the people had in that constitutional assembly that drafted the law, the final constitution, they acknowledged there that that will be a very limited program, and it's proven to be very limited, and it's proven to be at the moment it's very cumbersome because there are so many outstanding claims. And then the idea was that in order to catch people who do not fall under the restitution program, to have a very vast and all-encompassing redistribution program where you didn't have to go through all these hoops in order to prove your claim, in order to get your land back, but rather that in the beginning we also went through different stages with Mandela, Mbeki, and Zuma. People would in different ways get access to land, and that's also not been very successful. That's been largely driven by policies, and it's, as I said, it went in the beginning under Mandela. It aimed to get a lot of people who are living in poverty access to land. In the Mbeki era, it was more focused on getting more Black farmers into commercial agriculture. In the Zuma era, we are not sure what happened there, and now we're getting back on track, but that's also quite a difficult program. So, you know, whether that is reparations, one can also ask. I also know, and I want to put this in here, during the deliberations on the 18th Amendment bill of the amending the Constitution, now the Section 25 deliberations, a lot of questions were asked about the 1913 cutoff date, whether that does not restrict, because as Tembeka rightly pointed out now, a lot of the dispossession actually happened before 1913. When that act was passed, the dispossession already happened, right? So you're restricting that part of the reparations. But you know, my answer to that is yes, you can now talk about the 1913 Act, but nothing prevents government from promulgating a reparations act of sorts. And then the question is, what must that look like? Who must get reparations? And I think that for me is more of the pertinent question at the moment than whether, that's my personal opinion, whether Section 25 should be amended or not. My question is rather like, once the state has acquired the land, whether with expropriation or which any other way, how must that then be redistribution? Who do we envision must benefit from land reform? What are the criteria that we are going to use to decide who must benefit from land reform? And that for me, it's a difficult conversation, because I presume that some people will lose out, but it also speaks to what would a just redistribution of land look like. And I think that's very important. So I'm going to field that one to Tembeka. And yeah.
You know, I think what we need to do for a proper system to work, I think firstly, we need to settle all the claims that were put in under restitution. We know how many claims are there outstanding. I think it's about 6,000 outstanding claims. So those need to be resolved. Either the claimants get cash or they get restitution. But those claims need to be finalized. The second thing that needs to happen is that we need to build a system of customary ownership of land. There are 22 million South Africans, that's almost half the population, who live under traditional systems in which the rules of custom are the inherited, distorted rules from the colonial past. In the Cape, these were rules formulated by men like Cecil John Rhodes and men like Sir George Grey. In KwaZulu-Natal, these were rules established by people like Theophilus Shepstein. So we need to change the ownership system in the villages, in the so-called former Bantustan areas, so that there is greater security of tenure. That's urgent. That's 22 million people. The third thing we need is to focus on private property. The transmutation of one private asset from individuals to the next, it's clear that it will never produce liberation. Land is a limited resource. We had 9 million South Africans. I checked the numbers when I was writing Land Matters. We had a population of 9 million South Africans in 1913 when they passed the Native Land Act. We now have 58 million South Africans. It's clear that dividing the country and parceling it around is not going to sustain the actual levels of land hunger. So you have to confront private property and develop a new system in which private property is not a trump to other forms of holding of land. We need forms of nested systems. And unless we've confronted private property, land reform has no future. I've written extensively about private property as an idea that we need to confront. And I looked at the history, how it came about that the ANC as a liberation movement bought into private property. And I could only link it to the fact that the colonists linked franchise, which was a political right, to land ownership. And that is why a lot of Africans aspired in the late 1800s, from 1851 onwards, they actually aspired to property ownership because it was a mechanism to exercise political rights. But we need to rethink private property quite significantly. And as long as we are trapped in what I have described in my book as a private property paradigm, there's no future for land reform.
Thank you for your excellent response, Tembeka and Professor. I must say that I align myself with Tembeka's view, and I think it's quite curious whether or not the ANC has held on to the idea of private property, predominantly because they were never really a liberation movement, but rather a civil rights movement. And I think there was a letter that they had written to the UK, if I'm not mistaken, at some point, where they were begging for recognition as the educated masses or educated Black men. But I'll park that for now. There's an interesting question that has come out from Antonia. Pardon me if I have mispronounced your name. And the question is, I guess it's open to anyone, but the question is, I wonder what role processes of land registration play in sort of maintaining colonial structures, perhaps in entrenching notions of particular types of ownership. And I read that question, and immediately what springs to mind is, for instance, in Australia, the registration system that was brought in at the time, I don't want to get into the dates because I think I might get it wrong, and it's called the torrent system, and I do apologize if I've gotten the pronunciation wrong. But the idea behind it was exactly to create this abstraction of property, where property was no longer about the lived experiences of the indigenous people in Australia, but rather now property became something that was abstracted, was something that could be reduced into a title deed, which could be proven, and someone in England could just simply say, I own land 134, which is registered or recorded in this particular medium. I am interested in your views as to whether or not you think land registration plays a specific role, and if we're thinking about decolonizing land and property, should we start thinking about moving away from these sort of formal structures, such as land registration?
I don't know if Elmien wants to posit an answer. What I can say about this, in 2000, there was a book published by Hernando de Soto called The Mystery of Capital, Why Capitalism Triumphs in the West and Fails Everywhere Else. He wrote about his experiences. He was from Peru, and he wrote about his experiences in South America. Essentially, his thesis was that capital markets had failed in the developing world because they do not have a formal registration system of title to land. Instead, land is held through informal means such as communal associations. And then he said that the lack of formal title, even where the land is jointly owned, would prevent people from using property as collateral, such as accessing cash from the banks. And therefore, they are unable to unlock the capital, which is to be found in the land. And so in that sense, he found that capital in land is mysterious. It works for some, but it doesn't work for the majority. And he says that if you don't have formal title to the land, then your land is dead capital. And so he said, by registering it formally, you can activate it into productive capital. So that was his thesis. But ever since that book was published, experiences in the developing world have been the opposite. Every system of the formalization of the registration of land has collapsed. Even in Peru, where Hernando de Soto, and I must say this, a lot of World Bank economists have tried to sell this idea globally to the South, everywhere, to Africa. Why don't you follow Hernando de Soto? And what it meant for us as South African thinkers is to register the informal title of people in Soweto and Alex. The problem we have in South Africa is not the absence of registered formal title, it's the absence of land. The land is too little. We have too many people living in cramped conditions. I mean, this is the reality of South Africa. you have very few people living in large spaces of land. You know, if you look at the number of white men that own productive agricultural farms, 40,000 of them, 40,000, that's the number, right? And if you look at the hectares, it's something like 21 million hectares. So this is the problem we have in a country with 123 million hectares in total. I think the number is probably 40 million hectares. So that's the problem we have in South Africa. It's not a problem of formal registration. The problem is you must look at the history. You've got to start with the creation of native reserves. And that's why understanding Shepstein is so crucial, because Shepstein wanted native locations. And native locations became what was known as Zululand. But then it meant the places in Umhlanga, in Durban, in Pietermaritzburg, and elsewhere. Those were reserved for very, very few white people. So our crucial problem for decolonization is how you get more land available for redistribution. The system of holding that land is a secondary question, but it's not the primary question. That's not the urgent demand right now. Just to complete the thought on DeSoto, you know, DeSoto's theory was tested in Cape Town, Joslovo. The idea that even if you live in a shack, as long as it's registered in formal title, you will unlock debt capital from financial institutions. That's the basic theory. What they found was that there was firstly a problem of registration. The first question is, if you go to Cape Town and in shacks there, you'll find that there are 7, 8 people with claims to the title. You know, do you register it to the father, to the mother, to the daughter, to the son, to the uncle, or who do you register it to? Secondly, after registration, you have to apply for services, because formal title works together with availability of services, which means you must start paying municipal rates. But then you don't have jobs, and therefore you can't pay municipal rates. And what they also found is that when they went to the banks with these pieces of paper called registered title, the banks were not interested because the banks wanted income. You know, so the system that DeSoto theorized is good on paper, but it actually never worked in practice. In fact, that's one of the things I point out, that this, and it's the dogma of the World Bank that tells us that all you need to do is to register your shack. But it's completely unrealistic, and it has never worked anywhere, including in Peru, where DeSoto came from.
Yes, thank you. If I can also, I also feel very passionate about the subject. It's something that I'm now my research is growing in this area. I think just to say to Tembeka, I see the World Bank now moved away from DeSoto's ideas, which is great, because they realize that it's not a panacea for all issues relating to land tenure. But I think, you know, if you step back a little bit, when you read a lot about decolonization and land in at least the academic writings, that there's this question of what does land entail in terms of what's a decolonized meaning of land? And that's quite interesting. One of the authors wrote that, you know, in the decolonial thinking in Africa, land does not belong to anybody, but things built on the land can belong to certain people. And I think that's something that's worth exploring at least. But since we are where we are at the moment, where we do have private ownership, and that's what I meant with that hierarchy of rights. And then I think Tembeka picked up on that as well, the idea we have to reconceptualize property law in its entirety. I mean, ownership cannot trump just by default other rights, but we do need mechanisms and rules on how we are going to manage conflicting rights on property. And this then, so to bring this back to the idea of deeds registry, I see my colleague Elmien Wickham is also on the call, and we are trying to really advocate for a system, and that was part of the presidential panel on agriculture and land reform. One of their suggestions, a fourth program of land reform, which includes land administration, where land administration will find ways to record these rights without you know, pushing them into a title deed with a private ownership, but just record these rights in order to give more clarity or and to protect them. I think that's the biggest aim of a recordal system like that, but in ways, and that's why I also mentioned in the beginning, in ways that make sense to people. And I'm really hoping that that's somewhere the Interministerial Committee didn't take on that land administration system suggestion from the presidential panel, but I hope at least that was a seed that was sown for them to contemplate, because without such an extensive land administration system that can recognize and record rights in a way that makes sense to people, not in a way that makes sense to conveyances and people who's used to thinking in deeds and private property, I think that will be a step forward that includes some form of recording the rights of people living in terms of customary law. We need, of course, legislation for that as well. But, as Tembeka said, when you get onto the land, without precise borders, it is possible to say these are the borders and who's got what rights on what pieces of land. So that's something that I'm working on, and that I think is becoming more and more important. We've seen recently when the state, for instance, redistributed state land, that they redistributed state land with people living on the land for 30 odd years, but they were not seen. And that's why I brought in that idea of, if we don't have language to record these rights of people living on the land, because we don't have names or things for these rights, then people are going to disappear in a sense. And I think that for me is very important. So it does not have to be a private ownership on a title deed, but some form of recording in a way that makes sense. And then you have to work with people to ask them what would be good ways of doing this. And I think that, for me at least, is a long-term project. And I think that's actually also, you can link a lot of the decolonial ideas of, the idea that decoloniality deals with different ways of being, and democratization, sorry, there's my problem word, of ways of being. And I think, so that is what I'm advocating for.
Thank you both for that. So just because there's quite a number of questions that I would like us to get to, so I'm just going to rush through them and reserve my own commentary. There's a question by Ukanyo who says, let me just make it live. What about the society the Constitution creates? I think this was in response to your question, to your presentation, Prof. So it says, what about the society the Constitution creates? As per the Azanian philosophical tradition, its practitioners maintain that the South African Constitution creates a society fundamentally premised on a colonial dispossession, and as such, it can never produce a just land provision that dismantles this colonial dispossession.
Yes, so that is a very difficult question. Tembeka, you are next. No, I'm joking. And it's something that I grapple with. I mean, they make a convincing argument, but I think my problem, especially, and I'm just going to refer to what I've read from Ramose, because that is what I'm familiar with. If you look at his argument is, in order for us to have a post-conquest constitution, you have to abolish the constitution, hand back the land to the indigenous people under traditional authority. And it seems, at least that's how I read it, I might also read it wrong, I accept that, but it seems that he's suggesting to have ethnic enclaves. And that for me is dangerous and untenable, for one. I also don't, I always say, I don't know if I've not got the imagination of what that might look like, but as Tembeka also rightly said, I think, life has changed in the meantime, and the way that we live, the number of people that we have. So that's, that's something that I wonder about, but I don't want to simplify it only to that sort of practical ideas, because I think that's not doing justice to that argument either. But I do think it's, things happened in between, and this idea of being able, I think Julian Barnes has this really great quote of, You know, of course, you want to have a tabula rasa, but that's all bollocks. You cannot go to a place, things happened, and then that's why I liked also what Tembeka said. We have to grapple with the past. We have to deal with it in this process, and it's a very difficult and uncomfortable process, but it happened. So that's I would love to engage on this point, because it's something that I think of quite often. Also in the space of that Nkonyama trust case. You know, what would it look like if we hand land back to traditional authorities with this distortion that happened during colonialism? Who will benefit from returning? Who must benefit? And I think those are things that I grapple with, that I haven't found the answers to, that I'm very happy to listen to other people speaking on this topic.
Yeah, I mean, look, I must agree with Elmien on the suggestion that she makes. I think another way of approaching this idea of a return the land. You know, so this was the ANC's call in the struggle. Africa might be. Africa must return. So one way of looking at that idea of the return, it is a metaphorical return, in the same way as the idea of the surrender of the land. It's again a metaphorical surrender of the economy. It's probably not a literal surrender, nor is it a literal return of the land. But it is, I think, a confrontation with, that's why I quote William Faulkner. It's a confrontation, not with the legacy, but with the continuing forms of marginalization and dispossession that are replicated. It's this idea that the past is not really past. The past is still with us. It's continuing. And there is no surrender. There is no return. Instead, there's consolidation and there's continued marginalization. So I think another way of looking at it, it is an idea of a demand for justice, for economic justice, which permeates the structure of the Constitution. So that's one way of looking at it. So which means we're not looking at different objects, we're looking at the same objects, at the same object. The key to think about that is precisely how one engages with a white settler community that denounces its complicity to the past, but denies it at the same time. You know, the idea of F.W. de Klerk, apartheid wasn't that bad. You know, you are blowing it out of proportion when you're calling it a crime against humanity. Most recently, only a couple of days ago, maybe weeks ago, another leader of the opposition party in parliament repeated the point that actually apartheid wasn't that bad. So it's confronting that erasure of the memory of African people and confronting that erasure of the pain of African people and saying, well, your pain wasn't that bad. In any event, it's all relative, because if you look at the time, we as African people were also colonized by the British, and we had a war with them, etc. So what are you complaining about? So I think that's the demand to white society. It's the idea of empathizing with the pain of the suffering of Africans as a result of conquest. The second, of course, concrete step, quite apart from the empathy point, is the concept of reparations. Reparations have now acquired a bad name because they are all perceived as if, you know, these guys, the barbarians, want to take our assets, which we've worked hard for. You know, they look at these guys that are coming to take, and they don't want to work hard. You know, so I think the second element to this idea of the return, the metaphorical idea, at least in my conception of the return, is precisely what forms of reparations should be paid and from who. And that's where white society becomes very schizophrenic. You know, every time you talk about reparations, there's a sense of schizophrenia. Like, these blacks don't want us in this country, and let's go and do a lacha elsewhere. You know? So it's thinking about how you can establish a new society in a system in which everything about the past continues to exist alongside the new. You know, that's the problem. It's the Gramscian thing, you know, that the old are not dying, but the new cannot be born. So.
Thank you for that, Tembeka. So there's also another question from Tanvia Jiwa, and she asked, does the decolonization of the understanding of ownership and property take into account consideration of women's rights, or are the understandings of property and ownership inherently patriarchal? My very quick tongue-in-cheek answer to that is that Hobbes and Locke would probably say yes, it is patriarchal, but thank God that they are long gone. But anyway, Professor Elmien, do you want to take a stab at this?
Yes, so I think if you read around decoloniality and what it wants to achieve, and thank you for that metaphorical answer, Tembeka, that helped me to think about it. So, but what I think decoloniality wants to achieve, you know, we speak, there's pluriversality, sorry, my pronunciation is just as bad because I've only ever read it, but you know, the idea is not to have everyone the same. The idea is to create a society where everyone can be seen. And in that aspect, of course, it falls in, but also more pertinently, if you read a lot of the other decolonial scholars, the bigger theory is it's a stance against patriarchy. So in that sense, I would say definitely, you know, including women, recognizing their rights in land, recognizing it independent of men, as I should also add, is really part of the decolonial project, especially because women was seen during colonial times as perpetual minors. That's, you know, they must be rehumanized and seen. So I would say definitely yes, Tanvia.
Okay, just Tembeka, would you like to come in?
No, I agree. I've got nothing to add at all.
Perfect. And then there's a question by Dan Mafura. Dan Mafura says, while Tembeka problematizes correctly the colonial bastardization of property relations under customary law, and at what point, and at the same time, seeking to move away from a conception of property as necessarily private, what kind of model of ownership / property relation does he envision, which would not fall into the same trap of both one, colonial or bastardization of customary law, and two, free market fundamentalist or individualist private ownership? That is a mouthful. I will make that a live question, and Tembeka, please feel free to answer.
Dan. I mean, what I'm advocating for, I am asking for a tempering of the absolute nature of private property. It's exclusionary, absolutist nature of private property. So I am asking for a confrontation with that for a sustainable land reform program. What should the future look like? I think we already have many of these systems. We have systems of tenure in rural areas which do not operate on the basis of ownership, but they operate, on the basis of private ownership, which is the exclusionary nature of private ownership. But they operate on the basis of family, of community, and on the basis of shared rules of usages. So that customary system needs to be strengthened, not necessarily to be written down, but it needs to be strengthened. At the moment, it is challenged by chiefly power from the top, and of course by patriarchy, because chiefly power devolves a lot of power to the men of the villages. So I think the one thing is to strengthen the existing customary systems. You know, I wanted to just make reference to this judgment. It's just that at the time, I didn't feel I had the time to read it. But it's a very, very powerful judgment of the Pietermaritzburg High Court, in which it explains the nature of property holding. This is what it says. Under customary law, each member of each class or community is entitled to an allotment through procedures under customary law. Once a portion of land has been allocated to a particular individual or as residential or arable land, it is automatically taken out of the realm of communal ownership. It is demarcated and has fixed boundaries. The ownership thereof descends from generation to generation of such particular individual, owner, or family. However, unallotted and common land is communally owned by all members of the particular community under the administration of an induna or inkosi. However, both communal and individually owned land is defended by all members of the community concerned against attack or interference by outsiders. It is only unallocated land which requires prior written consent of a traditional community or authority for it to be encumbered, pledged, leased, or alienated by the trustee. I will remember this was in the context where the Ingonyama Trust had decided to convert the rights of occupation of people living in Ingonyama land to leasehold and to extract rental from them. And customary law is then developed here as pushback against this external imposition that seeks to create an artificial system of rental extraction. So one way is to strengthen customary systems. The problem, of course, is when you get outside of the customary systems into the so-called formal economy. You know, what forms there do you have in mind? Because most people in the formal economy, and that's something I've problematized in my book as well, is most people there, they regard a title as the ultimate symbol of achievement. What they want is title. And they resist the idea that when Africans are finally free, a new form will develop. They say, no, we also want the title because you've been giving it to the whites, so why should we not get it? But I think even there, one can think about systems of mixed leaseholds are one of them. Long-term leaseholds, you know, are one of those systems. It's still a formal right, but nevertheless, a lot stronger. And so even in the formal economy, one can design systems that are not as exclusionary. And we must remember that our model, South African model of property ownership in land was an extreme version. In fact, it was itself a bastardization of the Roman Dutch system, because the Roman Dutch system never created an environment in which the owner's rights trump everything. The owner's rights were always subject to other occupants. They were always subject to the state. They were always subject to other people visiting the property. But South African system took an extreme version of ownership. And so it's that extreme version of ownership that I'm saying it's time for us to revisit it.
Thank you so much for that. So I'm afraid we have to wrap up due to time. I think we were meant to finish at past. Thank you so much, Tembeka and Professor. I would love to detain you guys here, but I think on Tembeka's fees alone, I wouldn't be able to afford that. So I am afraid that we have to end it here, but thank you so much for a very interesting, incisive debate. And I'm sorry for all the questions we couldn't get to. Thank you for joining us. And I'm sure this will be one of many conversations that will be held through Oxford. And thank you for all the support that we received from Clara and my dean. Thank you guys so much. We appreciate this very, very much. And for everyone that's joined us, thank you for privileging us with your time. We hope we have earned it. And we hope that you enjoyed today's conversation.
Thank you very much, Sfiso. Bye.